Yes. I say your second is here in court. Your junior is here in court.
Okay. With me, my lord, is Judith Ejimofo.
Yes.
Appearing with me. Judith Ejimofo.
Yes, defendant. Yes. EOSH. Yes. Yes. BC. Okay. For the defendant. The matter is selected for judgment today and is ready. I'll read it. The claimant commenced this action by way of general form of complaint dated and filed on the 29th day of April 2024, together with a statement of facts, verifying affidavit, witness statement on oath, and list of documents, all pursuant to Order 3, Rule 1A of the National Industrial Court of Nigeria Civil Procedural Rules 2017. The claimant's claims against the defendants are as follows. 1. The sum of 517,799 naira 97 kobo, being the claimants unpaid salaries from 1st January 2022 to 30th September 2022 at the rate of 57 naira 57,553 naira 33 kobo per month. 2. The sum of 44,040 naira 6 kobo, being taxes deducted from the claimant's salary from 22nd February 2021 to 30th September 2022. 3. The sum of 2 million naira as general damages. 4. Cost of action in the sum of 1 million naira only. The defendant filed its statement of defense on the 6th day of June 2024, denying the claimant's claim and contending that the claimant is not entitled to any of the relief sought. The claimant filed a reply to the statement of defense on the 3rd day of September 2024, traversing the defendant's assertion. The claimant's case. These ones are facts of your case from the pleadings and evidence. So I will not be reading them. You will see them in your judgment. Issues for determination. The court adopts the issues formulated by the claimants as follows. First, whether the claimant has proved her case as to entitle her to the relief sought in this case. 2, whether Exhibit D1 is admissible having regard to the facts that the document was not signed during the employ of the claimant by the defendant. 3, whether the claimant is entitled to damage. Then party submission. This one too is very lengthy because it is the argument you canvass in your final written addresses. I summarize to some extent, but you know, summary is not summarizing everything. You have to bring out the live issues contended by the parties. So I go to the judgment. The court's decision. The court has carefully considered the pleadings, the evidence adduced by both parties, the exhibit standard, and the submissions of counsel. The key facts established are as follows. The claimant was employed by the defendant as a junior geoscientist effective from 22nd February 2021 on a monthly salary of 60,000 naira. 2. The claimant's employment was terminated by a letter of redundancy dated 1st September 2022. 3. The claimant was not paid her salaries from January to September 2022. 4. The parties are addendum that the claimant was not entitled to full salary from the period in question due to days of absence from work. 5. The defendant calculated the amount due to the claimant as 231,092 naira 98 kobo, which amount has been paid to the court's registrar during the pendency of the suit. 6. The claimant's calculations or claim is 517,799 naira 97 kobo, being salaries from January to September 2022 at 57,553 naira 33 kobo per month. Then I now take the objections. Objections as to admissibility of Exhibit D. The claimant objected to the admissibility of Exhibit D, Staff Policy Manual, on the grounds that it was not signed during the claimant's employment with the defendant in 2021, but during her NYSC program in 2019. The court admitted Exhibit D1 and ordered the claimant's counsel to argue the objection at the final address. The court has carefully considered this objection. The claimant's appointment in 2021 was a fresh appointment, was a fresh employment, distinct from her NYSC program in 2019. The Staff Policy Manual, Exhibit D1, was issued in 2019, and there is no evidence that it was reissued or ratified during the claimant's employment in 2021. Furthermore, the defendant's own offer of employment, Exhibit C1, dated 1st March 2021, contains comprehensive terms and conditions governing the employment relationship. The court finds that the defendant cannot rely on a policy document issued in 2019, particularly when page 56 thereof was withdrawn during trial. Accordingly, Exhibit D1 is hereby discountenanced and struck out for the purpose of this judgment. On Exhibit C6, the defendant objected to the admissibility of Exhibit C6, snapshot of handwritten quotation, on the ground that it is unsigned and the defendant is not its maker. The court admitted Exhibit C6 subject to the objection being argued at the final address. The court notes that Exhibit C6 is a snapshot of the defendant's accountant's handwritten quotations showing the amount of 421,458 naira 90 kobo as due to the claimant. The claimant testified that the calculation was done by the defendant's then accountant, Mrs. Ibukun. The defendant did not call Mrs. Ibukun to deny the documents or to testify as to the true calculation. The court finds that Exhibit C6 is admissible under Section 84 of the Evidence Act 2011. Being a computer-generated document, the claimants filed a computer certificate in compliance with Section 84 sub 2 and 4 of the Evidence Act. The document is relevant to the issue of the amount due to the claimant. On objection to Exhibit D, the claimant objected to the admissibility of Exhibit D5, Zuri Company document, on the grounds that it was not pleaded or front-loaded and no computer certificate was filed in compliance with Section 84 of the Evidence Act. The court notes that Exhibit D5 is a document from Zuri showing the claimant's engagement with the company. However, the defendant failed to comply with Section 84 of the Evidence Act 2011, as no computer certificate was filed to authenticate the document. Additionally, the document was not front-loaded as required by the rules of this court. Accordingly, Exhibit D5 is hereby rejected and discountenanced for the purpose of this judgment. I proceed to resolve issues for determination. Issue 1, Whether the claimant has proved her case as to entitle her to the relief sought. The court has carefully considered the evidence adduced by both parties on the issue of the amount due to the claimant. It is straight law that in civil cases, the burden of proof is on the party who asserts the affirmative of the issue, and the standard of proof is on balance of probabilities. See Section 131 sub 1 and 2 of the and Section 134 of the Evidence Act 2011. Amakumo versus Audu, Enem Chuku versus Okoye, all citations provided. The claimant has the burden to prove her entitlement to the sum of 517,799 naira 97 kobo being unpaid salaries. However, the claimant herself admitted in paragraph 14 of her witness statement on oath that she was not regular in attendance to work throughout the 8 months and cannot be paid full salary for those months. The admission is crucial. The parties are added them that deduction should be made from the claimant's salary for days she did not attend work. The dispute is only as to the number of days and the amount of deductions. The defendant tendered attendance register exhibit D2A and D2B to show the days the claimants attended work. The defendant also sent an email to the claimant on 3rd May 2023, exhibit D4, showing the attendance record and the amount due to her, 231,092 naira 98 kobo. The claimant's own exhibit C6, the accountant's quotation, shows the amount of 421,458 naira 90 kobo. The defendant's exhibit D4 shows the amount of 231 naira 92 kobo 231,092 naira 98 kobo. The defendant has paid 98 kobo to the court's registrar, that is the deputy chief registrar, during the pendency of this suit. The court finds that the defendant has proved on a balance of probabilities that the claimant was not regular in attendance and that the amount properly due to her is 231,092 naira 98 kobo. The claimant's claim for 517,799 naira 97 kobo is not supported by credible evidence. Regards the claim for salary in lieu of notice, the court notes that the claimant was on probation at the time of termination. Paragraph 6.1 of Exhibit C1 provides that during probation, both parties are required to give 2 weeks written notice to resign or terminate the employment. The claimant's appointment was terminated by a letter of redundancy dated 1st September 2022 with immediate effect. The claimant is entitled to 2 weeks salary in lieu of notice, not 1 month. However, the defendant's calculation of 231,092 naira 98 kobo already accounts for 1 day in September 2022. The court finds that the claimant is entitled to be paid for the days she worked in September 2022, not a full month salary in lieu of notice. The court notes that the defendant has already paid the sum of 231,092 naira 98 kobo to the court's registrar. The sum represents the amount admitted by the defendant as due to the claimant having reviewed the evidence. The court finds that this amount is reasonable and proper. On issue 2, whether Exhibit D1 is admissible, as discussed above, Exhibit D1 is not admissible as it was issued during the claimant's NYSC program in 2019 and not during her employment in 2021. The defendant's own offer of employment, Exhibit C1, contains the terms and conditions governing the employment relationship. The court therefore discontinues Exhibit D1. On issue 3, claimant is entitled to damage, whether the claimant is entitled to damages. The claimant claims general damages in the sum of 2 million naira for emotional trauma, and hardship suffered as a result of the defendant's failure to pay her salaries. It is settled law that damages are awarded as a consequence of some breach suffered with the intention of restoring the offended party to a parity of sort. CFCDA versus Unique Future Leaders International Limited, citations provided. The court finds that the defendant's failure to pay the claimant's salaries for about 8 months caused hardship to the claimant. However, the court also notes that the claimants contributed to the dispute by insisting on an amount that was not supported by evidence. The court awarded the sum of 500,000 naira as general damages to the claimant for the hardship suffered as a result of the defendant's breach of contract. Regarding the claim for taxes deducted, 44,040 naira 6 kobo, the court notes that the defendant admitted in its statement of defense that deductions were made from the claimant's salaries for payee tax. The defendant has a legal obligation to remit the taxes deducted to the appropriate tax authority. The defendant is hereby ordered to remit the sum of 44,040 naira 6 kobo to the Federal Inland Revenue Service as taxes deducted from the claimant's salary, and to provide evidence of such remittance to the court within 60 days from today. Regarding the claim of costs, parties to bear their respective costs. For all the reasons stated above, judgment is hereby entered in favor of the claimant in part as follows. The sum of 231,000 naira, 92 kobo, 98 naira, being admitted sum already paid to the court's registrar by the defendant, is confirmed as the amount due to the claimant. The registrar shall pay the sum to the claimant forthwith. The defendant is hereby ordered to remit the sum of 44,040 naira 6 kobo to the Federal Inland Revenue Service as taxes deducted from the claimant's salary from 22nd February 2021 to 30th September 2022, and to provide evidence of remittance to the court within 60 days from today. General damages of 500,000 naira is awarded in favor of the claimant against the defendant. Parties to bear their respective costs. Claim of additional salary of 517,799 naira 97 kobo less 231,092 naira 98 kobo are hereby dismissed. The registrar is directed to pay the sum of 231,092 naira 98 kobo already paid into court by the defendant to the claimant. All other reliefs not specifically granted are hereby dismissed. Judgment entered. Yes.
Ask God, please. Most grateful, my Lord, for
All
this
right.
judgment. Thank you, my Lord.
Okay. All right. I think by Thursday, your copies of judgment will be ready. By tomorrow, I will release it to the secretary. They will print it. Because I already typed, but they will correct the typesetting and whatever. Then CTC copy will be released to the parties by Thursday, by the grace of God. Yes.
Thank you.
Yes. Yes, that's all for today.